Okay, I'm back. I sent those emails.
Okay, great. We can get started.
Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, March 21st, 2022. In compliance with notification requirements of the city's open meeting law and sections 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak in a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comments on our particular matter. Back to you, Madam Chair.
Thank you. Can you call the roll, please?
Sure thing. Ms. Barnes? Ms. Brown?
Present.
Ms. Vaith?
Present.
Ms. Britt?
Here.
Madam Chair, we have a quorum.
Thank you.
We do have one postponement this morning. That is calendar number 21-181 regarding 3733 East 65th Street. And that's Rand Romano, owner, proposed to establish 7 residential units and 3 commercial units in a B1 local retail business district at that address. The appellant's representative contacted us last week and stated that she needed more time to meet with the council person and update the plans. So I told her that we can get her back on April 11th, but if you think that's too soon, we could do April 25th as well. April 18th is.
Yeah. 18th is November 25th.
Okay, April 25th it is. So calendar number 21-181 is postponed to April 25th. That's all that we have for postponements and withdrawals, Madam Chair.
All right. Thank you, Liz. All right, we'll move. We see that Councilman Griffin is here, and his first case is Murray Hill. So go ahead, Ms. Faith.
All right, thank you. As a courtesy to the council people, we, if they are present, we move their cases to the front of the line. So we'll begin today with calendar number 22-029. This is at 2024 Murray Hill Road. Carmen and Barb Pinzone proposed to establish retail use for gelato and production kitchen in a C1 multifamily residential district, contrary to the following sections of the Cleveland codified ordinances as stated in the agenda and the public record. To Ms. Brown for the oath.
Good morning. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address, please.
I do. Blaine Griffin, 11810 Larchmere Boulevard.
I do. Christopher Giancola, 2022 Murray Hill Road, Cleveland.
I do. Donald Pettit, 601 Lakeside Avenue.
I do. Jonah Bay, 2141 Prior Court, Cleveland, Ohio.
Madam Chair?
Thank you. Okay, who we have going on? Okay, yeah, history of the property. Thank you.
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 1984, it was changed to the current multifamily district. I only found in our Records Administration Office that in 1914, a permit was issued to erect a store and dwelling. And then there's one variance on file for this address in calendar 77-238. A variance was granted to change use from store to a dwelling. And that's all that I have that's relevant, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance and an area variance from the off-street parking regulations of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such as there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and the granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Okay, thank you. Before we continue, Liz, did you hear anything from Ms. Barnes at all?
I did get a text that she's trying to log in.
Okay, so she will be
I
here.
don't see her.
Okay. Okay. All right, thank you. Who'll be spokesperson for this case?
I'll be the spokesperson for this case. My name is Christopher Giancola.
Okay, Mr. Giancola, go ahead.
Okay, thank you all for having us, Madam Chair and the board. We would like to propose to erect our flagship Italian ice kitchen and retail location in my grandparents' house, which is at 2024 Murray Hill Road. They've had the building for a number of years. And a little bit about our company. We are an Italian ice company, which is an inclusive product. It has no dairy. It's only made with fresh fruit, pure organic cane sugar, and water. So it's a more healthy product. It's been very well received in our community. We've been in business for, this will be our third year. For the past 2 years, we've operated as a street cart selling on the sidewalk with a sidewalk permit, and we've been using our commissary location as a production facility. But we would really like to, and I think it's all culminating in relocating to where it all began in Little Italy, and really putting to use this beautiful storefront, which has been historically used for a multitude of different businesses since 1914, some of which being a shoe store, various other food processing facilities, and most recently an art gallery before it was converted in the, I believe, 70s or 80s into a residence. And if you would go forward, I believe in the presentation, there are some other uses of the building, which have been documented by the city of Cleveland and other local areas. But we do believe that these zoning codes do place a significant hardship on our ability to conduct business at this location, and we would like relief from some of the sections of the zoning code that are currently not permitting our use as a retail and production kitchen for our Italian ice. Furthermore, we would like to look into an emergency declaration, given as right now there are unprecedented shocks in the supply chain, which are causing everything from windows to awnings to some of the interior fixtures to have really just unbelievable lead times of upwards of 20 to 30 weeks, which even in the 2 weeks, it would save us for the emergency declaration. It would really help out our situation. Further, in the project summary, it shows that our production process uses no heat, which is very important for these mixed use kind of buildings, as our production poses no kind of threat to any of the other residents in the building in terms of heat. Further, our parking spaces, which we are requesting a variance for, we do provide one parking space for management in the back of the building. And I don't believe that was maybe caught on our project summary. And we also believe that our shop, once it's built out, would not be a sort of destination business. It would be kind of a auxiliary or accessory business to uplift and support the numerous other restaurants and businesses in the area that utilize a valet service or the street parking that we have in the neighborhood. And then I believe after this project summary, there's some more slides about the history of the unit and in the storefront in particular. This is from the, I believe, the ledger, permit ledger, showing when it was erected in 1914 as a store and dwelling. And then in the next page, I believe it would show the storefront system with a large 5 to 6 foot awning in front, juxtaposed with the 2009 photo. And then the next photo would, I believe, show the Sanborn fire insurance map, showing it actually contained 2 stores split half and half in that space. Then the next photo, I believe, is Joseph Rossi's grocery and meat market, which was there in 1934. Next photo, I believe, is the the shoe repair shop in 1955. And then in 1960, you can almost see a little outline of the original storefront before it was converted in the 70s. So we've done, quite a bit of due diligence finding the history of the building, and we would really believe it's time to restore it back to its former glory and create a more inclusive pedestrian environment by including our business in there. And then from the proposed land use 2020 from city planning does recognize the need for this building as a potential mixed use space, as the land use 2020 agenda really promotes mixed use and pedestrian environments. This is a site plan that we created showing some adjacent buildings. And I believe that may be it for that one. And then it shows just the location of Mount Granita Italian Ice as in relation to the rest of the businesses and other landmarks in the neighborhood. And then over here, we'll see just a couple of renderings that we created with the help of an architect and also with the help of the storefront renovation program. Tim Barrett, who is the chief architect for these historical buildings, he really influenced the design and the materials palette for the space so that we could be respectful to the historic nature of the space as well as the historic nature of the rest of the community. And then I believe lastly, this is some support that we've garnered over the past few months from many of our neighbors and local businesses and community leaders.
Okay, thank you. Sorry, Liz, Lori, what's this emergency declaration, Jazz? What does that mean exactly?
Madam Chairman, that's what I was wondering. There really isn't such a thing that I'm aware of.
That's what I thought. Okay.
If the board grants the variances, they will be in effect once the resolution is ratified, which I believe we don't have a meeting next week, so that would be the first Monday in April. And at that point, you would be able to go forward with your permits. I should say, if there was an appeal by somebody who opposed this, that could delay it, but they would have to go to the court and ask for a stay. So basically, once it's affirmed, you can get your permits, and that will be 2 weeks from today.
Madam Chair, this is Liz. There used to be in our rules and regulations the ability to do that. I don't have the rules and regulations that are posted on the website right now to confirm whether or not that's still in there. There was the ability back in the past for us to waive the 7 days. That was in the rules and regulations, but the previous chairwoman did away with that. And so that's not our practice anymore. So I apologize if that's still on the rules and regulations, that's still out there on the website. That would have been an oversight on our part, but that's probably what he's referencing. And no, it's not our practice to do that any longer.
Okay, thank you. I was like, what is that? Okay, all right, thank you. Mr. Pettit.
Thank you, Madam Chair. The Landmarks Commission fully supports the use in this case. As the applicant stated, he is going through the storefront renovation program. So this is not required to go to the Landmarks Commission, although I believe it still may be going through the design review process in Little Italy. So we fully support it, and we have no objection to the variances. And I'd just like to point out, Liz, that Ray Christosic from Little Italy Redevelopment just sent you an email regarding the project. But Landmarks is in support. Thank you.
I have that, Madam Chair, if you'd like me to read it in.
Yeah, I was wondering where Ray was. Okay, go ahead.
This from Ray Christosic, Director of Little Italy Development Corporation. He states that he will not be available to make it this morning. Little Italy Redevelopment has reviewed the plans for returning the residents on Murray Hill back to a commercial use for the Mount Granita operation. His organization is in favor of changing the use in this matter. They are also in support of the variance for the parking requirement. His reason for the support of the parking variance is that he feels that it will not be a destination business, but a business that people who come to the area and have parked their cars already will visit as part of their time here. We encourage the Board of Zoning Appeals to grant the variances necessary for Mount Granita to establish his new business in Little Italy. That's it, Madam Chair.
All right, thank you. Mr. Bay, did you want to say something?
Nope. Christopher Giancola did a great job presenting. Thank you all for your time. I think we're good here on my end.
Okay, thank you. All right, Councilman.
Thank you, Madam Chair, members of the board. I strongly support this project. The family has been really working hard on developing this for the last couple of years. They have tremendous amount of community support, and you know, not to mention they all live in the neighborhood as well. So I do also support the parking variance because I don't believe this is going to be a destination business. This is going to have more pedestrian traffic and others that will utilize this business. So I strongly support and whatever we need to do to make it happen, appreciate it.
Thank you, Councilman. Mr. Giancola, just one quick question. What will your business hours be?
Our business hours will most likely be for the first year as we get our bearings together. We'll probably follow the hours of most restaurants, most likely around 4 o'clock p.m. to maybe 9 or 10 p.m.
Okay, and what days?
Most likely Monday through Saturday. We would
Okay.
probably be closed Sunday.
All right. Okay, well, that exhausts the list. I'll open it up to my board for any questions or comments or motion.
Madam Chair, since there are no questions from the board, I will go ahead with a motion. We've heard support from the CDC, from Landmarks, from City Planning, from Councilman Griffin. It seems everyone is in agreement on the use of the business in the building in terms of it being sort of an accessory business, not a destination business, and that therefore the parking is not going to be an issue. So I move that we go ahead and grant these variances. I will also add that I think it's one of the most impressive histories of the building that I think we've seen. And so I commend the appellant for the excellent presentation for today.
Thank you very much.
Thank you. Can I have a second?
Yes, this is Member Brown, and I was going to say the same thing about the presentation and the history. It was very enlightening, and I appreciate it. So I second the motion.
Thank you, Ms. Brown with the second. Go ahead, call the roll, Ms. Kukla.
Thank you, Madam Chair. Ms. Brown?
Yes.
Ms. Bates?
Yes.
Ms. Britt.
Yes.
Calendar number 22-029 is granted. It'll be ratified the next time we meet on April 4th, and we will send the appellants a letter.
All right, thank
very
you.
much.
Good luck.
Madam Chair, I
Um,
did hear from Ms. Barnes. She will not be joining us. She is having technical difficulties.
She's actually on now.
Oh, I did get a
Good
text.
morning.
She
there we go.
made it.
Looks like she worked out
Okay.
the difficulties. Good morning.
All right, good. I was just about to make that announcement. Now I don't have
Right.
to.
I was just going to say that as well. Yeah. Sorry.
Okay, moving on to Shaker Boulevard.
All right. To Shaker Boulevard. And this case was postponed from January 31st, 2022. This is calendar number 21-204. This is the Superior Road Apartments LLC, located at 11201 Shaker Boulevard, number 102. I see that we still have Councilman Griffin with us. So let me read the case into the record. This is Superior Road Apartments LLC, owner and PATH, PATH, Behavioral Health proposed to establish use as a mental health center in an E4 residential office district. The applicant appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record. Of note, the first postponement of this case was made at the request of the appellant to allow more time to meet with the councilman and city planner Marka Fields. To Ms. Brown for the oath.
Good morning. I am swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply I do, state your name, and provide your address.
I do. Blaine Griffin, 11810 Larchmere Boulevard.
I do. Newly Theophylactus, 11201 Shaker Boulevard.
I do. Kent Whitley, 15919 Chadbourne Road.
Anyone else? Okay, Madam Chair.
Thank you. History of the property, please.
Thank you, Madam Chair. This property was originally zoned multifamily in 1929. In 2007, it was changed to the current residence office district. In the Records Administration Office, I only found that the address was part of a range of addresses for St. Luke's Hospital. And then in 1974, for the specific address, there were interior alterations to medical offices. And Madam Chair, that's all that I have that's relevant.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Okay, thank you. Who will be the spokesperson for this case?
I will. Newly Theophylactus.
All right, Mr. Theophylactus, go ahead.
Yes, thank you for taking the time to hear us today. I represent PATH Behavioral Healthcare, and we are seeking the variance to locate our office in the building at 11201 Shaker Boulevard, Unit 102. We are a community-based health or behavioral health organization. We provide telehealth. We do over the phone services. We will come to the house. We work at schools and any place in the community where the clients feel safe. We are 70% of all our services are in the community or telehealth. So one of the main reasons why we chose this location was because it is in the communities that we serve. We provide therapy services for individuals, groups, couples, families, and like I said, we also go in schools. On your screen right now is the office layout. As you can see, there are 7 offices that we will be using for counseling offices and administration offices. Yes, I already covered that. Okay, one more. So we also provide case management to help our clients with anything from housing, food, clothing, utility assistance, building skills, getting them signed up for Medicaid or any other type of service that they might need. We provide nursing services. So we assess the needs of the physical well-being for each client and help with healthy living for the body and mind. We offer a safe place to speak about medical needs, and we help them connect with the community resources to get primary care, physicians established, pediatricians, dentists, or others as needed. And we focus holistically on the client. We have nurse practitioners and psychiatrists that provide medication as needed based on mental health diagnosis. We prescribe at most a 30-day supply of any type of medication, and our clients come in at least on a monthly basis to see the prescriber and to make sure medications are correct for them and they are not having adverse side effects. We also have what we call our PATH mobile pantry, where we go out into the community to provide for immediate needs, such as serving hot meals, giving out non-perishable foods, hygiene supplies, clothes, hats, gloves, coats, blankets, and a lot more. We do events like free haircuts for students before school starts, giving them supplies for school. So we have a small bus, imagine half the size of a full-size school bus, that we utilize to go to these events and hold our own events also. Here's a couple of success stories from our clients. Homeless individual came to us, had nothing but the belongings that they carried with them. After working with a PATH provider team, they were able to obtain assistance, a place to live. All of their needs are met. They report that they have not felt this good about my situation or myself, and I can't remember how long. I am safe and warm for the first time in many years. Then our second success story, a guardian of a client who received services through PATH at their school. The guardian reports they are acting so much better, you can see a real difference. They are doing so much better at school. The teachers tell me daily how much easier school is for them. I can barely recognize this child. You've changed our lives. So we have a team approach in taking care of our clients. We believe in providing a care team to each client. The care team will work together to provide quality care to each individual. Care is individualized for each client, allowing the specific needs for each client to be the main focus. And then following, we have some demographics on Ward 6 that we were able to do some research and were able to find. Like I said before, one of the main reasons we picked this office was because it was in a community that we serve, the type of communities that we serve. We have approximately 24 offices in Southern Ohio, from Cincinnati all the way over to Portsmouth. We also have offices in Utah, Vermont, New Hampshire, and Missouri. So we are a very well-established organization. We've been doing this for several years now, and we saw Cleveland had a great need for behavioral health, mental health services. And that's why we chose to come to Cleveland and are now trying to open our first office at 11201 Shaker Boulevard. I'll take any questions if anybody has any.
That's the end of your presentation?
Yes, ma'am.
Okay, thank you.
Thank you.
Mr. Whitley?
Yes, ma'am. I'm hearing support for Path.
Getting a little bit of echo again there, Mr. Whitley.
Yeah.
Sorry about that.
So you're just saying you're in the support role? Oh, so you don't
Yes,
have anything
ma'am.
to say? Okay.
Yes, ma'am.
All right, thank you. Just one quick question. What will your hours of operation be for this business?
Monday through Friday, 9 a.m. to 6 p.m. Or as needed. If the client needs to see us before or after those hours, we'll make arrangements.
Okay, thank you. Councilman?
Thank you so much, Madam Chair. I support the project. One of the reasons why it was postponed is because I wanted Mr. Theophylactis to have a community meeting with the Ward 6, regular Ward 6 community meeting. He did. He came and complied. The residents asked some tough questions. They wanted to make sure that they understood how this facility would operate. One of the biggest questions was transportation. And I believe that they were, pleasantly surprised that they will be providing transportation for a significant amount of their clients to and from their appointments. One of the biggest concerns that we have is that we don't want to become oversaturated with, facilities for mental health. And we know we have about 2 already. And we just approved another one about a week ago.
Yep.
However, there is a community need, and there is a community need for, mental health services, and especially in the minority communities, and having minority mental health facilities. And I know there's a tremendous amount of stigma around this, and once again, we don't want to become oversaturated because we are in a process of a renaissance in this area. But I believe the way that this program is structured, as well as the management history of Mr. Theophylactis and his team, that we can support it. We will be working close with them to make sure that we don't have any unintended consequences. However, we do support it.
All right, thank you, Councilman. Maurice, I don't see a city planner here, so is that you?
Yes, Madam Chair, I spoke with Marka Fields, who's the neighborhood planner for this region, and she also echoed basically what Councilman Griffin has said and is in full support of this project and appears to be a very good resource for the community.
Great, thank you.
The building, I think, is situated in a good way for this type of use.
Yes.
It's somewhat separated from the neighborhood, plenty of parking. It's a good use.
All right, I'll open up to the board for any questions, comments, or motion.
Madam Chair, since there are no questions from my fellow board members, I'll move ahead with a motion. We appreciate the testimony from the appellants. also from Councilman Griffin and City Planning. It does seem, as Mr. Rulins mentioned, that the building is excellently situated for having been a medical facility in the past. It appears that it is a good fit for this sort of business. And we appreciate Councilman Griffin's statement that there have been extensive and engaged community meetings with regard to this, and the community seems to be satisfied with the answers that they received. And we have the hours and the service area, and this does fulfill a need specifically in the minority community. So with that, Madam Chair, I move that we go ahead and approve the variances for calendar number 21-204.
Good morning, second.
All right, Ms. Barnes with the second. Go ahead, call the roll, Ms. Kukla.
Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Vaith?
Yes.
Ms. Britt?
Yes.
Calendar 21-204 is granted. It'll be ratified on April 4th when we meet again, and we will send the appellant a letter.
All right, thank you.
Thank you very much. Have a
Thank
good
you.
day.
Good
You
luck
too.
to you.
Good luck.
Thank you.
Bye-bye.
All right, Madam Chair, looping back to the first item on our agenda today. This is a Board of Zoning Appeals, calendar number 22-011. Kevin Sullivan appeals under the authority of Section 76-6B of the Charter of the City of Cleveland and Section 329.02D from the decision of the Commissioner of Assessments and Licenses to deny application LU OU 21-00187 that was filed February 7th of 2022. To Ms. Brown for the oath.
I am swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address. Are you muted?
Yeah, Mr. Hilo, you're muted.
There you go.
Thank you. Henry Hilo, 323 Lakeside Avenue, and I do.
I do. Kevin Sullivan, 1291 Ethel Avenue.
Anyone else?
No, that'll be it.
Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is appealing an administrative decision. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right, thank you. Mr. Sullivan, is this your case?
Yes, it is.
Okay, go ahead.
I'm appealing it. I had my toll license. I've been in the business over 40 years. How I make my livelihood. I need this to make my livelihood.
And if I could speak on his behalf, I handled the case, and he did not plead to an OVI or a DUI. The reason there was a...
Who's speaking right now?
I'm sorry, for the record, Henry Hilo. I apologize.
And you are?
I'm an attorney, and
Okay.
I was the one that handled this case. And the docket was submitted as part of our record. And you could see from the docket, there was numerous pretrials in this case. And the resolution of this case was there's some underlying issues that were involved. And as a result of that, there was a significant reduction from the OVI statute in this case to the physical control. In addition to that, if you look at the docket.
Mr. Hilo,
Yeah.
Can you just give us a background on what's going on here? Because you're going right into OVIs and all that, which we don't cover here at BZA. It's about he wants to appeal the ticket or the license or whatever.
Well,
so can you just talk about that?
Yes, because the reason it was given that he was not given the renewal was they said he was convicted of a DUI. And I'm submitting that he was not convicted of a DUI.
Okay, that introduction was helpful. All right, go ahead.
And I apologize for that. And when if you look at the docket speaks for itself. There was a reduction from the original charge to this physical control. It was negotiated between ourselves and the city of Cleveland. In addition, I think it's also significant to note that when we did resolve this case, the city of Cleveland, along with the Honorable Judge Lugo, allowed him to get his license back immediately. He did not even have a suspension of his license upon resolution of this case. Had there been a alcohol suspension in this case sufficient to an OVI, he would have had a suspension of 1 year of his license with occupational privileges. He did not have that when we resolved this case. And you could see it on the docket when you go to the March 19th of 2021, his administrative license suspension was terminated and there was no court suspension imposed. He received his license back immediately. I would further state that this individual who made this decision just looked at the original charge and did not follow through with any other conversations with the city prosecutor or the court or myself when he rendered this decision. He rendered it strictly on the complaint, i.e. the ticket, and did not render it based on the ultimate finding by the court based on the negotiation between the city of Cleveland and myself. And because his decision has put my client economically in a disadvantage, one of the reasons we also were able to resolve it, not only with the facts on this case, he has no other alcohol-related events in his driving record. And I believe right now you're 60 years old? 64. He's 64 years old. He looks much younger than what he is.
Okay, is anyone from the city here about this? Or Lori, did you do some background on it or?
A little bit of background, and I'm not here to argue on behalf of licenses and assessments or to tell the board what kind of decision it should make. I would just note that the offense that the appellant pled guilty to was an alcohol-related offense, lack of physical control under the influence. So basically, that in common terms, I think would mean that the defendant was physical control means you're in a vehicle in a position to drive with the keys, but not driving. So that's what the plea bargain that was made in this case, and undoubtedly the appellant's record or lack of DUIs, if that is the case, had something to do with that. So that's all I have to say, and that's informational.
And I would offer to this honorable board that not only was that part of it, but the underlying facts in this case, and also physical control here, as accurately stated, the vehicle wasn't operated at that time, was the concession that was made in order to resolve this, along with the fact that he got his license back immediately upon resolution of this case.
So here's where I'm confused. So at the time that license and assessments, did they revoke his license? Is that what happened exactly?
At the time, the complaint, the ticket's issued, your license is automatically suspended.
Okay, so at the time this happened, his license got suspended, and then through some negotiations here, we got to an agreement, and he was able to get his license back, and you're appealing the original suspension.
Well,
Madam Chair, just to clarify, when you're talking about the license being suspended, I think Mr. Hilo is talking about the driver's license was suspended, and which it automatically is if you're arrested for a DUI. And when it was resolved, the court gave him his driver's license back. I think what you're talking about, the license to operate a tow truck, I don't know what exactly what the timing of that was, or what the circumstances were as far as.
Yeah, that's what I'm confused about.
I don't know whether that was based on the initial charge or the charge that he pled guilty to. I don't have that information.
It was based on the initial charge, because when he went to renew, this case was already over. And when he went to renew, they denied it, not based on the resolution of the case, but on the initial charge. He went to renew after this case was over. So someone just looked at the doc and saw what he was charged with, and I'll defer to Mr. Sullivan right now.
After this happened, my tow license was still current. You have to renew it every year at the end of March. When I went to renew it, when it was denied.
Okay, so this whole case got resolved on what date exactly? Because this is a lot of writing.
Yeah, it was resolved on March the 19th.
On March the 19th. So after March 19th, you got everything resolved, and then after that, you went to go get your tow license from the city, and they denied it based on the original charge, but didn't see that you had already worked through an agreement.
That's correct. You renew it. I have to renew it again by March 31st, or I have to apply for a fresh license by March 31st.
Okay, so what date did you go in to ask for your license renewal?
I don't have the exact date in front of me, but I think I probably did it in March, early March.
It was after you resolved this.
Yes,
It was after March 19th. I'm trying to see if I might have something here that it was after March 19th.
Okay, so I think I'm getting this clear.
Madam Chair.
Okay. Yes.
We have LaRonda Talton, who has just joined us on the call. She is from Commissioner Stevens' office.
Oh, that'll help. Ms. Brown, can you swear her in, please?
Yes. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, say I do, state your name and your address, please.
I do. LaRonda Talton, 601 Lakeside Avenue, Cleveland, 44114.
Thank you, Madam Chair.
All right, thanks, Ms. Talton. We're just trying to get to the nuts and bolts of this case here. So from the appellant's point of view, we have that he had an initial ticket issued, which affected his license. He was able to negotiate out of that. And at the point in time when it was time for him to renew his tow truck license, he is saying that the city rejected it on the original ticket he received and not seeing that that ticket had been negotiated out. So what is the city's perspective on this?
I do apologize. The print is small and I can't see. What is the amended charge?
Physical control.
Physical control, okay. Well, what the process is for the tow truck driver's licenses is that once the Division of Assessments and Licenses receives the application, it is forwarded over to the Cleveland Police impound lot for the Cleveland Police Department to review the application and compare it to the codified ordinance and make the decision. So the decision of not to issue the license is at the sole discretion of the Cleveland Police Department. And I'm trying to find, because Detective Sergeant Saridovic who reviews the applications. She was not able to make the hearing, but I'm trying to find the response that she sent. I know the ordinance states that if you are, is it charged of the offense? I'm going through the codified ordinance right now. I do apologize. I was tardy. So codified ordinance section 677A.15 reads that no driver's license shall be issued if an applicant has been convicted of driving a motor vehicle while under the influence of intoxicating liquors or drugs. That's conviction.
You mean a tow truck? We're here for the tow truck license, so
Yes, that's for the tow truck driver's license.
yes, okay.
So yeah, that's what this is, the no driver's license, the tow truck driver's license.
Yeah, that's what we're here for. It was rejected and he's appealing that rejection. So I need to know what the city's position was when they rejected it, when he went to go get renewal, why it was rejected.
Right, and I was reading the process. The process is that once the Division of Assessments and Licenses receives it, we forward it to the Cleveland Police Department. So it's upon their review, is if they determine that the application is not in compliance with the ordinance, then they either approve or deny the application.
What was the date?
I apologize. Go ahead.
I'm sorry. What was the date that you received that it was?
Mr. Hilo, you have to ask questions through me.
I apologize, Chair. Could you ask what was the date that was forwarded to the city of Cleveland?
Ms. Talton, you can answer that.
The date we received the application, or the date it was received to or forwarded to the Cleveland Police Department? Could you please clarify?
Madam Chair, if you can ask her the date it was forwarded, both the date that you received the application and the date it was forwarded to the city of Cleveland.
Okay.
Yeah, we'll need both of those actually.
Okay, I'm sorry. I'm trying to go through my emails.
Meanwhile, Lori, I have a question. If this essentially is denied by the police department, I mean, is this still an appeal for us? Like this is.
I think it is, because the denial was made by the Division of Licenses and Assessments.
Okay.
She's indicating it was based on information given by the police.
Given by the police department. Okay.
Yeah.
Okay, it was forwarded over to the Cleveland Police Department. I do apologize. It says October 1st, 2021. And Sergeant Saridovic returned it to us. The date appears as October 26th, stating that it's denied. And I believe I forwarded this information. I'm not sure if you have it, but there was 2 sections that she denied. It was driving a motor vehicle while under the influence of intoxicating liquors. Additionally, and possession by a tow truck driver in his or her tow truck of opened or unopened beer, whiskey or wine, of drugs or other stimulants not specifically prescribed for him or her by a medical doctor for his or her private use, or of gambling equipment or paraphernalia, stolen goods, or contraband property of any kind. So this is the sheet we received back from her, and then we mailed a denial letter to Mr. Sullivan on October 26th of 2021 to United Towing Company stating the driving under motor, the offenses that I stated with the offense date of December 11th, 2020, and it has a conviction date of March 19th of 2021.
Madam Chair, just for the record, he was driving his own personal vehicle. He wasn't, it was a pickup truck. It wasn't a tow truck. There were no gambling equipment. There are no drugs. There's no allegations of drugs anywhere.
No, I think she was just reading the whole.
I
She
understand.
was just reading the whole. Yeah, we're not accusing him of that. She was just reading the whole statute.
I just want to make sure it was clear. And also, it wasn't the tow truck he was driving either. It was
Okay, but it seems they reviewed this well after March 19th, and the police officer still came up with the same reason to reject it. So this is where we have to figure out if that was proper or not, I guess.
If I may be heard at the board's discretion, it's kind of disappointing that there's no look to see by the officer. There's no record here where the officer even talks to the prosecutor or the court. I think when you look at the docket, if the court in any way thought that it was inappropriate, one, the court would not have taken the plea, or two, the court wouldn't have granted driving privileges, not driving, would have given the license back immediately and allowed the reduction in this case. And physical control, I know you have a lawyer on the board here. Physical control by its very nature does not involve operating the vehicle. It means that one is behind the vehicle for the purposes of the individual. It just means that you have access to the vehicle. It doesn't mean you're operating the vehicle. And I mean, and he was allowed to get, and I have proof, he has his license. He was allowed to get his license, you know, in his commercial license. He was able to get it immediately. So the judge, who knew the facts better than just someone forwarding over something to a police person who's reviewing a number of these different applications to an individual who's 64 years old, and this is his livelihood, and then we summarily reject it. The economic hardship it causes him, especially in the times that we live in now, and with no prior OBIs or alcohol-related offenses, that's why I'm asking for the review by this board.
All right, I think we have the information we need right now. I'm going to open it up to my board members to see if they have any further questions for the city and or the appellant.
Madam Chair?
Yes.
This is Member Brown, and I cannot, well, I did read the materials that were shared in advance by the secretary. However, I did not understand the level of the negotiated plea. I guess I read where it said maybe about the ticketing. So one of the questions that I have is, should this be presented or back to the police officer who denied it in order to understand if they spoke to the prosecutor or understood the negotiated plea before rendering a decision? I'm sort of concerned to overturn that without understanding the level of due diligence that they performed. Is that of importance to our deliberation?
Ms. Brown, this is Lori Wagner. I think what has been established here is that this went to the police department well after the plea bargain was accepted by the court. And therefore, I think, first of all, this hearing is here, and if the Division of License and Assessments wanted to present the police department, they could have. But I think it's also fair to say that the police department knew what this gentleman had pled guilty to, which was which was an alcohol-related offense, but not an operational offense. They also knew that the court had given him his driver's license back. I don't know that anything would be added to this by talking to the police officer. After 6 months, they had access to the same documents that you did, and they knew what he pled guilty to.
Okay. I thank you for providing that perspective.
Madam Chair, also, this case was not a City of Cleveland case. It was a Highway Patrol case. So the person that was reviewing this record was not even his department, and that person was not even involved in this case.
Just say that doesn't make any difference. I mean, the police department saw what was on the Ohio Bureau of Motor Vehicles record and knew, did not know anything about the actual offense itself or the circumstances of which were present when the citation were issued, although they may or may not have looked at an actual police report. I don't know, but they had access to the same information.
Thank you.
Madam Chair, no further question. Thank you.
Great. Any other board members with questions? If not, I'll entertain a motion.
Madam Chair, I would like to thank our secretary for sending out the information in advance for us to review this case. I think we're clear on the timeline and the review by the CPD came after the plea was reviewed and the appellant's license was reinstated for him. I am someone who has worked closely with CPD. I am very much someone who believes that you need to follow the letter of the law. But in this particular situation, I would say that given Mr. Sullivan's age and and the hardship of him not being able to earn his income, I might be inclined to give him some grace in this situation, since he has no previous record of substance impairment in his driving record. That would be my comment. I'd welcome any other comments from my colleagues on the board.
I think that means people are agreeing with you, Alana.
All right, with that then, Madam Chair, I'm going to move forward with the motion.
Can I make a comment? I apologize. I was having trouble getting in. This is LaRonda from Assessments and Licenses. Through the chair, can I make a comment?
Yeah, before we start our motion, go ahead.
I apologize. So the restrictions within the codified ordinance are very specific, and some of them even provide a time frame within which, applicants can be issued a license. For Section B, it does state if the conviction is more than 5 years old, then the commissioner, can make concessions. So there are concessions built within the ordinance, but we see these situations on a daily basis with driver's licenses because we issue various types of driver's licenses. So I just wanted to put that on the record that the ordinance doesn't say, okay, you have this offense, but you haven't done anything else, so we're going to give you this license within 12 months of your license. So I just wanted to just let you know that the ordinance is very specific as to who can have a driver's license.
Yeah, I appreciate that. Thank you.
Thank you.
Go ahead, Ms. Faith.
Okay. We'd like to thank Ms. Tulton for that additional input. And I will move forward with the motion, Madam Chair. Given all the testimony we've heard today, and it's not something that we typically see, and we don't take this lightly. We certainly are respectful of our other agencies, particularly the CPD, the Cleveland Police Department, and the Commission of Assessments and Licenses. This is a bit of a difficult situation, but given what we've heard today, and again, as I stated, Mr. Sullivan's age, the expectancy of him to continue his work, and the hardship of him not being able to earn an income. And I'm going to also say that the record shows a lack of any previous violations with regard to substance abuse or driving while under the influence. That I move that we go ahead and give Mr. Sullivan some grace and allow him to renew and to overturn the ruling for his tow truck license on calendar number 22-011.
Have a second, please.
Ms. Barnes, second.
Ms. Barnes with the second. Go ahead, call the roll, Ms. Coco.
Thank you. Ms. Brown?
Yes.
Ms. Barnes?
Ms. Barnes, yes.
Ms. Vaith?
Yes.
Ms. Britt?
Yes.
Calendar number 22-011 is granted. The decision of the Commissioner of License and Assessments is overturned. It'll be ratified on April 4th when we meet again, and we will send the appellant a letter.
Thank you all for your consideration. Madam Chair, thank you for the dignity with which this was conducted. I appreciate everything. God bless you all. Be safe, everyone.
Thank you. Good luck.
To you as well, and we don't want to see Mr. Sullivan here again. Thank you.
All right, moving on.
Moving on, that concludes all of our cases, Madam Chair. We can go to old business.
Madam Chair, we have Alger Road still.
Yeah, I thought we had one more.
Oh. I am missing that.
Madam Chair, I can read it in if you'd like.
No, I can read it. I can read it off the screen. I just don't have it printed out. So this is calendar number 22-026. This is the application to change use of existing two-family residence to a three-family residence in a two-family residential district, contrary to the following sections of the zoning code, of which there are three. And I will turn it over to Ms. Brown for the oath.
I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply I do, state your name and your address, please.
I do. Matthew Riegelsberger, 14847 Alger Road, Cleveland, Ohio, 44111.
Anyone else?
I notice Adam Davenport is online. Are you planning on commenting on this case, Adam? Okay, I guess we can move forward.
Madam Chair.
All right, thank you. History of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, I found that in 1929, a permit was issued to erect a dwelling in a garage. There are no variances on file and nothing of note in the more recent history.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance and area variances from the minimum lot size and off-street parking regulations of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and the granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
All right, thank you. Mr. Reglisberger, did I get that right?
Yes, ma'am. That was good considering all things. And
All right, thank you. Okay, go ahead.
Reigelsberger, Roethlisberger, I get them all. But yes, that was
I'm
correct.
sure you do. Okay, go ahead, present your case.
Okay. First of all, bear with me. This is my first WebEx meeting, despite the whole COVID thing and everything. So I'm glad I'm able to get this out of the way. And thank you for having me on here and listening to what I have to say. So there's a picture of it there. A little introduction of myself. I own it with my twin brother. We moved to Cleveland about 6 years ago from surrounding suburbs. In 2018, I purchased this duplex in West Park. I enjoy living in West Park and all it has to offer with its parks, restaurants, and friendly neighbors. And my goal here is to add an additional living space to provide a convenient and affordable option for another contributing resident in the neighborhood. Next, yeah. These are the declinations for the zoning codes. Next page breaks them down a little further into detail. 33.7.03, three-family dwelling is not permitted in a two-family district, first allowed in multifamily district. 355.04B, in B area district, minimum lot area of 2,400 square feet per dwelling unit is required. 7,200 square feet lot is required. 4,800 square feet is what's proposed. 349.07A, all parking spaces and maneuvering areas shall be paved, drained, and graded within parking area. The parking, that's the back there. There is an additional pad that there's actually paver bricks down there. That's up to code for vehicular use. That has a 2% slope towards the floor drain. And also there is ample street parking out front on both Alger and the cross street at Fernway and Alger. Three family variances. Attached are properties that have received variances for same zoning codes. These properties are located in the same zip code and are within 2 miles of my residence. There's 1.2 miles away on Warren Road. It's all self-explanatory there. Lydian Road, 1.1 miles. 3640, it's 1.1 miles away, 1.2 miles, etc. Here are some references from surrounding neighbors, ranging from right next door to across the street and so on and so forth. They all had no problems with it and even gave me their numbers to allow for phone calls, references, and so on. Here's a little bit of attic details. There's roughly 700 square feet of living space from what would be the knee wall to the knee wall. Dormer is on the east end of the attic, which is the front of the house. There's existing egress in the rear of the house. And I've been consulting with several architectural firms that specialize in these types of designs and builds. If granted this variance, I will move forward with receiving firm quotes. Then I will make my decision on which firm will be designing the drawings and pulling the permits. Thank you all for your time today. I would greatly appreciate, sorry that one went away, your consideration for granting this variance. And that's it.
Okay, can you give me a little history on the house here? Do you have existing meters for all three of these layers, or are you
yes,
gonna have to do all of that?
No, so actually I just recently pulled a permit with the city, the building department, and it is the new meter base is in, so it's a 3 meter. There's not a third meter yet, obviously there's no unit up there, but that is all permitted and in place.
Okay, so I was just checking because sometimes people buy the house and the third floor's already been done and then they didn't realize that it was not a legal third floor. So we're just gonna be clear that you want to transition this attic into a apartment.
Correct. Yes, ma'am. It is
Okay,
bare bones right now. It's just the way it was originally,
okay, gotcha.
not finished.
All right. Well, yeah, West Boulevard, that area has a lot of three families there. So I will open it up to the board for any questions.
Madam Chair, it looks like Adam Davenport has joined. I'm not sure if he had any
Oh,
comments
he
to make.
needs to be, yeah, he needs to be sworn in if he does.
I do need to be sworn in. Yep.
Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply I do, state your name and your address.
I do. Adam Davenport, 601 Lakeside Avenue, City Planning. Thank you. Sorry, I was on the phone with a different kind of case. The tow truck case took a little bit of time this morning. So
Yes, it did.
We're I feel like in city planning we're generally supportive of these variances, given support from either the neighbors or the adequate kind of parking situation that the owner sees on this property. Also happy to support, I feel like, an owner occupied space in this case as well. One that the owner will attend to and take care of over time. So in short, we're in support of this variance. Thank you.
All right, thank you, Adam. All right, back to my board.
Madam Chair, I'm curious to know if we've received any statement from the councilman.
I have not. Ms. Kukla, have you received anything from the councilperson?
No, I have not.
Okay.
No.
Madam Chair, if there are no questions from my colleagues, I'll move ahead with a motion.
Go ahead.
Okay. We thank Mr. Reigelsberger, thank you, for your testimony. It looks like you've already addressed the parking pad and the drainage issue. Thank you for including the 2% slope. That's something we don't typically see in the details. And thank you to Mr. Davenport from City Planning for his comments and support. Madam Chair, this is again fairly typical of what we see in this neighborhood. Again, we welcome the fact that it's going to be owner occupied. And so I move that we go ahead and approve these variances.
All right, thank you. Can I have a second?
Member Brown, I second.
Ms. Brown with the second. Go ahead, call the roll, Ms. Kukla.
Ms. Barnes?
Yes.
Ms. Brown?
Yes.
Ms. Vaith?
Yes.
Ms. Brett?
Yes.
Calendar 22-026 is granted. It'll be ratified on April 4th when we meet again, and we will send the appellant a letter.
All right, good luck.
Thank you, guys. I very appreciate that.
You did
You're
a good
welcome.
job, Mr. Reigelsberger, for your first time on a WebEx.
I appreciate that. It means a lot. Thank you.
Yeah, good luck to you.
Thank you. Thanks, guys.
All
Take
right.
All
care.
right, old business, 1 through 3 without objection.
Without objection.
Everyone else? Okay. All right, and I need a motion to go to executive session. We got a couple things we need to talk about.
Oh, Madam Chair, I did put that second, or is it the third, request for rehearing for the Hessler project.
Oh, yeah.
I believe I sent you the documents on that.
Yes.
You did.
Yeah, so I believe that the request for rehearing, I believe we had substantial reasons from before we denied it before. And so I feel like we should deny it again. Board, I will welcome your input, but I believe the same situation applies, that there was no new evidence presented in asking for this rehearing again.
I would agree with you, Madam Chair. everything we've heard. I mean, this has been unpacked extensively, and we've heard anything that they're arguing as new information. We have heard already, so I'm in agreement.
Madam Chair, I see it slightly different. I agree that they've presented all the information. I think what's different is that the garage where they presented the lease, where they said they would have parking spaces, is being torn down. So they won't have parking spaces. I also would, to my colleague's point, there was a lot of conversation about buses and students and no need for cars. But it's the fact that the garage is being torn down, which is what is different. And that's what I'd like to offer.
Okay, thank you. Anyone else? All right, Miss Faith or Miss Brown want to give me a motion for either direction, for rehearing or no.
Madam Chair, I am going to move that we deny the rehearing.
Can I have a second?
Second, Ms. Barnes.
Ms. Barnes with the second. Go ahead, call the roll, Ms. Cooper.
Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Rehearing request for 21-152 is denied. We will send the applicant a letter.
All right, thank you. Can I have a official motion to end the meeting today so we can go into executive session?
Madam Chair, I move that we adjourn.
Thank you. Without objection, board?
Madam Chair, could I just clarify that you're not adjourning, you're making a motion to go into executive session? The meeting is still.
The meeting's still happening. Yeah.
Yes.
All right. With that, then, Madam Chair, I move that we move to executive session.
All right. Without objection, board?
No objection.
All right. Thank
Okay,
you.
1 second while I